welcome to the Amy Noel on Dyslexia YouTube channel. I'm really excited to make this video today. It's all about alternative dispute resolution in special education. Just to start out, I want to say I'm not a lawyer and I'm not giving you legal advice. This is only an informative video from the perspective of a parent of children with dyslexia. All of my sons are on the dyslexia spectrum, I would say, and they all have ADHD, but 3 of them have IEPs for reading, writing, and spelling, and 1 of them has a 504 for ADHD. Make sure you check out the video I made last week about FAPE. I will link it in the description of this video. If you or your children have dyslexia, you may be interested in this shirt. My brother and I, my brother is dyslexic, we designed this shirt together. So let's say that you've had a disagreement with the school on their offer of FAPE. FAPE stands for Free Appropriate Public Education. So you don't agree with the services that they want to provide for your child, you don't want them to provide those, or you wish they would provide things that they denied. Alternative dispute resolution is one of your options in handling this disagreement. The next couple of videos are going to be on mediation, due process, and filing state complaints. I don't want these videos to make it seem like schools are the bad guy. A lot of schools can be supportive and open to doing what is best for the kids, so you really need to just gauge your school, get advice from advocates, and see what kind of district or school you're dealing with. That being said, there are also a lot of risk involved with special education law, so parents need to be aware of all of these things going in. In some school districts where they are likely to file due process against the parent, it would be important for you to skip straight to due process so that they have less to hold against you. When you look up alternative dispute resolution, or ADR, the legal definition is that it is anything outside of the court case to settle a dispute. So in the legal realm, mediation would be under alternative dispute resolution. But in special education, it's its own term. In special education, ADR refers to a negotiation between you and the district, or you and the SELPA. Basically, you meet with the SELPA or the district representative and you talk about your concerns and you come up with a plan that you can both be happy with. If that's not possible in the ADR, you don't like their offer, then you can decide to move on to mediation or due process, or filing a state complaint. The ADR can be so informal that there is no settlement agreement, but it's all just in speaking. Sometimes in an ADR, they will write up a settlement agreement. So this is basically protected under contract law. Legally, when somebody gives you their word or says that they'll do something, that's also enforceable, but you have to be able to prove that they said they would do it. So you either need to have a recording of what they proposed in the ADR, or you need to get it in writing. Trying to enforce the settlement agreement from an ADR under contract law might not work. It might get thrown out because there wasn't an enforceability clause. Like in the contract, it needs to state this is enforceable by law and it is an offer of FAPE. If you don't include the term FAPE in the contract, then the IDA laws might not apply to your case. But the IDA law might still apply to your case. It's kind of a gray area. Comment down below if you have anything to input on this. I'm going to talk about the pros and cons of ADR. First off, it can be quick. Right after the IP meeting where you have the disagreement about FAPE, you can call up your SELPA director and request a meeting and maybe have the ADR within a week. Another pro is that it's free. There are no lawyers involved or third parties. It's perfectly fine to bring an advocate to an ADR, but not a lawyer. Another benefit of ADR is that it's non-adversarial. You're just business partners trying to work out this problem. In an article in the San Diego Tribune about special education law, a parent said about ADR, it was much more successful than due process where you sit with lawyers. This was much more a conversation of what does he need, how do we do it? Another benefit can be that it can possibly give your SELPA director or district awareness of their lack of appropriate education for certain disabilities. After one of my son's IEP meetings where I had requested a structured literacy program for him and one-on-one instruction, they denied it, and then I called the special education director and set up a meeting. We had a phone conversation because it was during COVID-19. She still denied my request for structured literacy and one-on-one instruction, saying that they needed to do more evaluations on my son. However, by me speaking with her on the phone, she said that another parent of a child with dyslexia had concerns about what they were offering in the district. This parent speaking with her had prompted the formation of the dyslexia work group in our district to put in place best practices for students with dyslexia. She invited me to be in the work group and put me in touch with this other parent. Some of the cons of a ADR, it's an internal process, so it's not covered by federal or state procedures. Another downside is that if you're going to sign any kind of contract, you need to have an understanding of contract law. You need to understand everything in there, or you need to say that you need a couple of days to go over it and get an outsider's opinion, like an advocate or a lawyer. You want to make sure in the settlement agreement that it doesn't say that you're signing away your right to file due process unless you're positive that that's okay with you. For example, if you're getting some really expensive service, the contract will also state how long you need to wait to file due process. Could be 1 year, 2 years, 5 years. An advocate told me that you need to be aware that in multi-district SELPAs, when you go to meet with the district, they'll bring in somebody from the SELPA, an administrator from the SELPA, and they'll say that it's a mediator. But really they're just representing the district, the SELPA director. So they'll try to call it a mediation. You need to call them out and say that SELPA administrator is just acting as a representative of the district, because a mediator is supposed to be impartial, but the SELPA administrator or director that is there is going to be working for the district and not for you necessarily. Please comment down below any further information that you can, because like I said, this video is to give parents information. So if you can add to it, please do so in the comments of the video. And I will see you next time. This is kind of hard to explain.